Henry Matlock appears with his attorney, Patrick Blanchard. Joshua Andrews appears as court-appointed guardian ad litem for the child. This matter comes before the court at this time for further proceedings. This court now is in receipt of recommendations of the guardian ad litem following his investigation. I trust this has been shared with each of the parties in this case. I will ask each party for their remarks regarding this recommendation and report and where we need to go from here. I'll start off with Mr. Blanchard on behalf of Henry.
Yes, Your Honor, thank you. Yes, we've read the recommendation of Mr. Andrews, and it's our request that the court adopt the recommendations as the orders of the court. He did make reference to the adopting the parenting plan that was attached to the order that was filed with the court on September 23rd. We ask that be followed as well, Your Honor. We're pleased with the schedule. The parties are communicating by our family wizard now, and it's our hope that once this is settled, that the parties will work together in Larry's best interest. That'll be our obligation and our attempt to do so, Your Honor.
Very well, Mr. Blanchard. I understand your position. Jordan?
What the guardian ad litem typed up didn't quite make sense to me because it said from Mondays to Wednesdays, something about those days being one or the others, but then also the other party gets her on Wednesdays and Fridays, and then something about the weekend. I'd just like for that to be clarified on what that schedule would actually look like.
Your Honor, I'm happy to do that, or perhaps Mr. Andrews would want to clarify that. Either way is fine.
Okay.
I'm happy to do it, Your Honor.
All right.
Yes. Yes, my understanding, and of course, because Mr. Andrews and I work in this every day, it would be that Mom would get every Monday and Tuesday, Monday starting at 3 o'clock or after school until Wednesday at 3 o'clock or after school. And Father would have every Wednesday night and Thursday night from 3 o'clock or after school until Friday at 3 o'clock or after school. And then on Mom's weekend, she would have the child at 3 o'clock or after school until Monday at 3 o'clock. And on Dad's time, his weekends, he would have the child after school on Fridays at 3 o'clock or after school until Monday at 3 o'clock. And that schedule would go the alternating weekends. Every other weekend would be Mom's, and every other weekend would be Dad's.
Jordan, I don't see that there's any real crossover. It does appear that each part of the week is set aside specifically to an individual parent. So after Mr. Blanchard's recapitulation of Mr. Andrews' recommendations, do you have any further questions regarding it?
Yeah, that seems a little hectic with her also being in school and all the back and forth, and that seems like a lot going on. And we have to like make sure that we keep track of all of each other's stuff to get it back and forth to where it belongs at the right house. And that's already a lot as is for the Mondays and Wednesdays.
Why did you not consider a week-to-week plan, Mr. Andrews?
Your Honor, I know that was what the father was recommending. Frankly, I felt like that was a lot of time away from each parent, and I wasn't trying to make, even though I didn't give a lot of credence, I think, to some of the more extreme concerns that both parents were leveling, I guess, towards the other. I felt like a more frequent back and forth would maybe be beneficial towards alleviating some of those concerns that they would be able to see the child, make sure the child was okay, after the other parent's parenting time. And given the fact that Mr. Matlock was already receiving Wednesday overnight to Thursday mornings, and then every other weekend, it seemed like it would just be a natural progression for his parent time to go Wednesday night through the weekend or Friday evening, and that Ms. Martin would continue to receive the Mondays and Tuesdays through Wednesday, or Monday evening through Tuesday or Wednesday evening that she's already receiving.
Mr. Andrews, was the young age of this child a factor in that decision as well?
I I think that I'm a little bit more open to the longer periods of time for older children, but with younger children, again, to be honest, in my personal practice, I usually start out with the recommendation of a rotating 2-2-3 because that really minimizes the amount of time that the child is away from a parent. But in this particular case, I thought that may be too much back and forth, too much to keep track of. And again, with the way that the temporary parenting plan was already set up, it just seemed like a static 2-2-3 where it was always Monday, Tuesday with one parent, always Wednesday, Thursday with the other. And again, in this case, where Mr. Matlock was already receiving Wednesday overnight to Thursday morning, it just made a lot of sense, even though that it results in kind of a 5 days in a row with one parent if they have the weekend. It still, I think that given Lyric's young age, as long as it is a schedule that is the same, it's a reliable schedule, she will be, in my opinion, children that age, as long as they know it's a routine. This is the routine. This is where I'm going to be at as they get older. Then they don't have any ill effects from back and forth. It's when they don't know any given day of the week where they're supposed to be because there's no routine. It's up in chaos. I think that they have that problem.
All right. Ms. Martin, any additional remarks from you?
Yeah, wouldn't say that she's adjusting any better to the overnight stays. If I'm still having to pull her off every time, the only time she transitions well is when Henry comes to my house and he picks her up and I put her in his car. Any other time, if I have to go over to his house to drop off clothes or drop her off in general, I have to pull her off of me and she's screaming, crying, saying she doesn't want to go. And that to me doesn't seem like adjustment. That seems like it's going to cause issues for her in the future.
May I respond, Your Honor?
You may.
Yeah. Your Honor, my concern is this, and you know, reading Mr. Andrews' report and the statements made to him by Ms. Martin, that he didn't give a lot of credibility to what she was saying. This is not the experience that my client has had. So we think that the schedule, as Mr. Andrews succinctly put it, is that it was more easy to follow on a Tuesday, Thursday over, and then the weekend, every other weekend. And that's what they'd like to do. I think the rotating 2-2-3 schedule is really confusing for a child and confusing for parents. So we think the recommendation is soundly based and we'd like to see it followed, you know, adopted and followed.
The court also believes, after review of the entirety of the report and the file in this case, that this parenting plan is currently in the best interest of this minor child, and the court will adopt Mr. Andrews' guardian ad litem recommendations in their entirety, finding that it is a sound parenting plan, which has been suggested to this court. And I do understand the mother's concern. It is a valid one. However, I think this is something that is worth attempting. And I think it would be incumbent upon a parent to show, after a considerable period of time that this parenting plan has been in effect, to show why the plan is not in the best interest of the minor child. It is not the view of this court that it should block its implementation at this point. I think it needs to be tried. And if there's adaptations that need to be made consistently with the best interest of the child, that can always be done in the future. But for now, the court will adopt Mr. Andrews' recommendations as the orders of the court in regards to a parenting plan. I'm going to place the responsibility of drafting of what I'm going to entitle shared custody decree on Mr. Blanchard. I think this will have an impact on child support, will it not, Mr. Blanchard?
It will, Your Honor, and I had one pay stub from Ms. Martin. I have provided her with 4 pay stubs for my client. She has been claiming the child each year. If that would continue, it would make actually, again, if they'd share the expenses, that would be fine. If she's going to pay the direct expenses, I can do a child support calculation either way. I know that Ms. Jordan said that she has ceased to work, but she does have the capacity and capability to work, and she has a pay stub which would show what she earns. I'm going to, with court's permission, submit a a worksheet. And if she wants to claim the child each year, then there's probably going to be no child support obligation. If they alternate the exemption each year, it would be $50 a month based on my calculations for Mr. I'm sorry, Mr. Matlock. And then if they had a shared expense plan, if with her having the lower income that she would pay the direct expenses, then it would be somewhat higher. I calculated that at $127 a month, but with no adjustment for the value of the tax exemption.
All right. Blanchard, I want to make sure I understand what income figure for the mother would be used.
I used what her income was from Walmart. She was working 14 to one pay stub. She gave me $14 an hour times 78.5 hours bi-weekly. I took that times 26 weeks and divided by 12 and came up with 28,574, which turns out to be 2,381 a month. And my client's income is at $3,200 a month based on his pay stubs. And so I did the calculation based on those numbers, Your Honor. My calculation showed that my client had about 57% of the joint income, and she had about 43%. Let me see, let me pull that up. I'm sorry, I came up with 57.3 and 42.7. There is no daycare cost. Ms. Martin has the child on the state health insurance plan at this point. So that's the calculation I came up with, Your Honor.
All right, Ms. Martin, apparently Mr. Blanchard's numbers are based on income that you had from Walmart, which appears to be a fair number for you. Would you agree with that?
I guess so. I don't work anymore, so
How
that,
do you financially survive without working?
well, my boyfriend,
Okay.
he works and he's taking over the bills since I'm not working anymore and all that.
All right.
Your Honor, per the guidelines and based on her recent income, I simply imputed that amount to her as what she's capable of earning.
Understood, Mr. Blanchard. Is it your intention, Jordan, to continue to pay the expenses for the child?
Yeah, we will.
Okay. I just want to make sure that when you make that representation that you have the financial capacity to actually do it.
Yeah.
And if you say you do, okay. I think that gives you some direction, Mr. Blanchard. And
Yes.
is it your intention, Jordan, to continue to claim the tax dependency benefits for the child each year?
I do plan to.
All right. I think you have that direction as well, Mr. Blanchard,
Yes.
in ultimately completing your child support worksheet.
Yes, Your Honor, I can do that. And what are we today? So would make that effective starting December 1 of 2025, Your Honor.
Yes, and it was really the intention of the court perhaps to delay the start of this plan until December 1st as well, so that the child support decrease and the parenting plan are implemented on the very same dates. And that would give the mother and father a short transitional period while this journal entry is being prepared and circulated, and actually have this go into effect on December 1 of the year 2025.
Okay.
Now, I do understand that there is a holiday parenting plan that would be incorporated into this plan as well. It's a rather detailed plan. It
Yes.
undoubtedly covers Thanksgiving. And so that plan would need to be followed for the Thanksgiving holidays this year, despite
Okay.
the fact that the shared custody plan would be implemented as of December the 1st. Furthermore, if you're going to use exact language, and I would prefer to the extent possible that you do, Mr. Blanchard, when you're incorporating the guardian ad litem's recommendations, he uses the term in paragraphs A, B, and C, should. I'd ask you to change that to shall.
Yes, Your Honor.
These now become court orders rather than recommendations. So I think it's important to change that one term in his text.
As to the recommendation, Your Honor, I can attach the recommendation, but I thought I would go ahead and explain it a little more fully in the order as well. Is that okay? Or we just attach?
I don't want the guardian ad litem recommendations attached.
Okay, thank you, Your Honor.
He's got a relatively short actual recommendation section. that should be incorporated as much as you can, word for word, with that one change I ordered. But I really don't want the report becoming part of the order.
Okay, thank you, Your Honor.
Okay. And I do want all current parenting orders, visitation plans, holiday plans, other standard clauses incorporated into one order.
Okay.
Mr. Blanchard.
In one order, okay, I will not file a separate parenting plan. And also the parties were ordered and have been communicating by our family wizard. I want to include that in the order as well, Your Honor.
Indeed, that's an existing order that the court wants carried over. If it's successful, let's maintain what's successful.
I agree.
And that's good communication between the parents.
Thank you, Your Honor.
I really hope that this opens a period of true co-parenting, a lot of sharing of information, sharing of ideas, just to work together for the best interest of this child. That's what the child deserves.
Okay.
And I hope that you two can continue to work together, recognize the constitutional rights to parent on each side of this case, and then raise this little one successfully. Mr.
Ron,
Andrews, thank you for your work on the case.
Thank you, Your Honor.
Your Honor, may I ask one question, please?
Yes.
Every order I've had to submit it pursuant to Rule 170, and Ms. Martins has not signed it. I don't want there to be any delay with this, so I would really strongly encourage her, based on what Mr. Andrews' recommendation is in the court's orders today, to review it and sign it and get it back to me so I can file it promptly.
Ms. Martin, I think that's a reasonable expectation of Mr. Blanchard, that you'll promptly look at it. And if it reflects what we've discussed here on the record, even if you don't agree with 100% of it, if it's what we've discussed, you should sign it and send it back.
Okay. Last time there was not something that was discussed. Well, it was discussed, but you declined it. And then he turned around and changed and added it and gave me an opportunity to decline it as well. But I didn't have the rights or the means to be able to decline it.
Okay.
That's not an accurate statement, Your Honor.
Okay. Well, we're talking about moving forward from here, Jordan. So again, if it's what he sends is a fair reflection of the parenting plan and the orders which we've gone over today, then you should approve it promptly and get it back to him. I don't want
All right.
delays in the implementation of the parenting plan as of December 1st. I want things to go smoothly as of that date.
Yes, and I am so sorry if there was stuff that I was supposed to be signing. I did not know that.
Okay. Well, we want to make sure you're involved in this. That's the whole
Okay.
point. Okay. Very good.
Thank you, Your Honor.
Okay. If there's nothing further at this time, then the Matlock and Martin matter will currently be in recess. Good luck to the parents in the future. This meeting may be ended for all as the court is in recess.
Thanks.
Thank you, Your Honor.
Thank you, Your Honor.
This matter comes before the court at this time for further proceedings regarding the verified motion to modify custody. Court will first make the observation. This is the first setting in regards to this motion. The court has reviewed the motion, finds that it's properly verified, and does colorably state a prima facie case, which warrants this court taking further action in regards to this motion. Ms. Martin, are you opposing the relief sought in this motion filed by Henry?
For overnights, yes.
Okay.
I'm totally okay with him getting parenting time a few hours throughout the week and a few
Okay, you
days.
say that. Okay, let me stop you there. You've read the allegations in this motion, and Henry says that he hasn't had parenting time since December, if I recall. Why is that?
Because one night I was asking, he had her all day, and I asked him to call me after her nap. He did not contact me all day, and he'd already had her the day prior to as well. And I was just wanting to get in contact with my child and seeing how she was doing. And then it came into a whole argument that he wouldn't let me contact her. He wouldn't let me see her because he was too afraid that she'd want to come home if she's seen her mom. And so then I said, well, if you're not going to pick up the phone, then I'm going to show up and I'm going to take her home with me. And then he made me have to call the police to be able to even see her. So, and to get her back into my custody. So since then, the cop told him that unless there was a court order in place, that he could keep her for as long as he wanted. And I'm not okay with that because I'm the one who's been raising her for 3 years all by myself. He's been in and out of her life.
Okay, and the little girl is 3 now?
Yes.
Okay. I trust, Mr. Blanchard, that your client is still pursuing the relief sought in his motion for this court to adopt a new parenting plan.
That is correct, Your Honor. I'd like to have the opportunity to argue if the court will allow it.
You may.
Your Honor, we dispute much of what Ms. Martin has already stated. My client said that when he ever has a child in that particular weekend, which would have been the weekend covering December 20th, that she was blowing up his phone with text messages and phone calls, and finally it was interfering with his opportunity to have meaningful contact with his child, and he just stopped responding and stopped taking her calls because it was just relentless. And then she's the one who called the police and came over to do a welfare check. And my client, as I stated in my motion, he complied with the police officer's request. He brought the child out. The police officer noted there was no problems with the child. The child did go to see the mother, and then the mother would let him have the child back, even though there was an agreement that he would have the weekend and the overnight. And they had actually modified the existing parenting plan where he was starting to have more time with the child, including weekends. And then when he said, I want my child back, the police officer said, do you have a court order which gives you overnights? And he said, no, I do not. So he said, I don't have any authority. This is a civil matter. Bring this matter to court. So that's where we are now. Then from and after December 20th, he's had no contact whatsoever. Ms. Martin has said over and over again that she is the sole parent in this matter, that what she says goes. I have attached several exhibits, many exhibits in which she states that same thing, and saying she doesn't care what he says, she makes the determination. My client said that he has worked hard to have a relationship with his child, that his parents are here and they have a relationship with the child. And to be cut off from this child for 77 days now has been extraordinarily difficult. I don't want to go through point by point of my motion because the court has already read it, or point by point with regard to my exhibits. But I would point out that one of the things we stated in our motion is that Ms. Martin has a habit of smoking marijuana consistently. In my exhibit 8, she talks about her purchase of marijuana when she has a text message with my client. We certainly ask that she be required to submit to a hair follicle drug test today at our cost. Let us know where it would be done in El Dorado, and with our firm credit card, we'll pay the cost. If the court wants my client to submit to a hair follicle drug test, he will do the same thing at his cost. We've asked for some pretty serious changes in the custody arrangement. We've asked that he be designated as the primary residential custodian, and we think that's appropriate under the circumstances. I point out in my motion the fact that she has violated virtually everything in the temporary parenting order about how you parent a child together. And then under the statute 233203, I point out 7 or 8 issues where it certainly favors my client. The rest are neutral or not applicable. He wants to be involved in his child's life. I put first, we want him to be the primary residential custodian and giving her regular parenting time. The second thing is, although it'd be difficult under the circumstances, he would work his best to do a shared residential custody arrangement, but that implies that both parties are able to work together. We think that she has not been willing to work with him. And with that in mind, that would, I think, support more him having primary residential custody and her having a regular parenting schedule, which we have proposed to be every Wednesday from after work till 7:30 or 8, and then on the weekends that she have every other Friday from 5 or 6 until Sunday at 5 or 6, and follow the holiday schedule that was in place in the original parenting plan. We think it's a strong basis, Your Honor, for the court to honor our request at this time, and that's what we're asking. And at the very minimum, that the court would order a regular parenting schedule, which is our our exhibit. I'm sorry, it's our exhibit 4.
Which is alternative mom primary. Is that the one you're referring to?
Well, the last one is, and it's just because we want regular parenting time that she would be primary, although we don't think she deserves it, but anything to get him started to have meaningful contact with his child. And that's the last gasp that we'd have, but we do think that we've justified a reason for changing custody in our motion and arguments today.
All right. Ms. Martin, I'm sure you're familiar with the proposal proposed permanent parenting plan, alternative mom primary. And what's wrong with that plan?
Me being alternative or me being primary?
You being primary, but it sets forth, I think, a rather structured and actually a fairly common parenting time schedule for the father. Are you just saying that he shouldn't have the child overnights ever?
Not until she's old enough, like a little bit older. She screams and cries even when he comes to pick her up just for a few hours. She doesn't want to unlatch from me.
Okay.
I feel like she's not comfortable enough to stay overnight. She's been with me for 3.
Of course, keeping the child from the father for over 70 days, doesn't that help contribute to some of that? Deprivation of the relationship between father and child, you don't think that has a negative effect on the child's willingness to go see her dad?
No, because before I was allowing him to have a lot more than even what we had scheduled. I was allowing them to have a lot of time and she was still doing it.
Okay, now I'm going to go back to Mr. Blanchard for a moment. Mr. Blanchard, tell me about your client's household. What environment does this child go into when she goes to visit her dad?
Okay, my client has a significant other, a fiance who's a very good person. She's about to have their child together. There's a 2-bedroom house. The child of the parties has her own bedroom. The new baby will be in a bassinet in their room for a period of time. In her living arrangement, as I put out in my motion, she has 6 people living in the house, and the child sleeps in the room with her and sleeps in a bed with her. We would also dispute her allegations that the child screams and doesn't want to go with the father. That's not my client's experience, nor is it the experience of the grandparents who are here or his significant other who is also here. And if we went to an evidentiary hearing, all these people would testify as to a good relationship with the child when he's allowed to have contact with the child.
All right. Thank you for that additional information, Mr. Blanchard. What is apparent to the court is that the parents aren't working well together to share parenting time and parenting rights involving this child. The court generally is fairly protective of newborns, small infants. The court is always trying to be cognizant of who's qualified to really raise children of that age. But this child's toddler age. She's 3. And I'm sure she's a handful at times, as 3-year-olds are. Mr. Matlock, are you really in a position to handle as much parenting time that's on your schedule, which is a full weekend at a time and every Wednesday night?
Yes, we've actually done it for longer. It's usually a Wednesday and a Friday every week, and then we get some weekends. Whenever we have her, we have no problem with her. She's well behaved. We get her in bed at a reasonable time, 9 or 9:30, and she's up the next morning at 7 or 8. We have breakfast, lunch, and dinner. Kendall's got educational games on her phone that help her with her speech and pronunciation that she actually really liked. We have no problem with her keeping her entertained and eating healthy meals and just keeping her.
All right, Mr. Matlock, what about this claim that the child has real adjustment problems for several hours after going from the mother's home to yours?
In the beginning, yeah, it was a bit of a struggle to get her used to sleeping over at my house, but by the third night that we had her, not third night in a row, but just third night in general, she was having no problem going to sleep. She doesn't have any problems going to sleep. I could tell her to go to bed and she'd fall asleep right there. We do. I'll read her a couple of books that we have. She likes to read Dr. Seuss, Green Eggs and Ham, and we got a couple of Bluey books that she likes me to read to her. After that, she's out cold the whole night. No problem.
Okay. I expect straight answers on this, Mr. Matlock. Are you currently on probation for any offense?
No,
Do you have any criminal cases pending?
I do not.
Ms. Martin, I'll ask you the same questions. Are you currently on probation for any offense?
No,
Do you have any criminal cases pending?
no, Your Honor.
Okay. Again, it's apparent to the court that the court is going to need to set up a structured parenting plan for these parties to follow. And I'll warn both parties that if the court makes this order for specific times, I will expect both of you to follow it to the letter. If you can't agree on variations, which is a shame, and I think that's tragic, because special circumstances will come up from time to time. But I would really hope that you two can learn to work together to be a little bit more flexible. But the court, I think at this point, needs to set a rigid schedule. At least at this point, the court will implement the proposed permanent parenting plan, though I'll call it a temporary parenting plan. Alternative mom primary, which was filed in the case. I don't see an exhibit number on it as far as the court file is concerned, but it's the proposal which calls for the father to have parenting time every other weekend, from Friday at 6 p.m. to Sunday at 6 p.m., every Wednesday from 5 o'clock p.m. to 7:30 p.m., and any other time that the parties mutually agree upon in writing, which I don't have any real optimism is going to happen until you two develop some sort of cooperation and rapport with one another. But I do want to set forth that every other weekend and every Wednesday night schedule. I think this child needs to get reacclimated to the father in the father's home. And I find it tragic that there's been a long deprivation period here because the court believes that the Wednesday night should be the first visit rather than an overnight. Next Wednesday will be the start of this parenting plan. I trust starting your weekend, not this weekend, Mr. Matlock, but the weekend after is consistent with your schedule?
Yes.
So yes.
Okay. So the mother will have this upcoming weekend, and then you would have the one after that on the every other weekend rotation. That gives you the Wednesday night to kind of get reacclimated with your daughter. There may be a little bit of transition problem there at first. She hasn't seen you for a while. I'm sure that after a couple hours, she'll get reacclimated and she'll be in a better position. I don't see any solid grounds here to avoid overnight visitation between father and child. I don't see that in any way he's forfeited his rights to do that. I think that maybe you two shouldn't be contacting each other during periods of the other person's parenting time. There apparently has been a problem with multiple phone calls and texts and communications. Mr. Matlock, you're the child's dad. You don't have to give constant reports to mom. You don't. But I would say this. There is probably no greater resource for information concerning your daughter than mother. Use her as a resource if you need her. If she starts acting a certain way or start developing a certain problem, giving her a call or sending her a text, hey, here's what's going on. You have any ideas about how to deal with this? I know it's hard for you to do, but again, she knows the child, as well as anybody, if not better. So use her as a resource. I also am somewhat optimistic here, Mr. Matlock, that you have a significant other in the house who's about ready to become a mother herself.
Yes.
Fair statement. And then you have some supportive family around you.
Yes.
Is your mother, does she live close to you?
Yeah, we have my mom and then Kendall's entire family. We've already talked to them. They're more than willing to help us with Lyric whenever we need
Okay.
to.
Other than the mother of your child, your mom is probably the next best resource if you ever need any parenting direction. Okay.
Yeah. Yeah.
Don't hesitate to use her as a resource if you need to. All right. I think that this is an appropriate temporary parenting plan. Mr. Blanchard, I know you have not had an opportunity to confer with your client about this. I will need to know at some point whether your client is going to be satisfied with that as the ultimate result of his motion currently before the court or not. I know that may need some discussion.
Your Honor, we would suggest a review date. We understood that there would probably be a transition period that would be ordered by the court. That's why we proposed the alternative plan. We would like perhaps a review date, and we'd also like the court to rule on whether or not both parties should submit to a hair follicle drug test. If Ms. Martin, as we suspect, would show up with at least marijuana in her system, we'd like the court to have that information, and we'll pay for the cost, and my client will submit to the same hair follicle drug test.
That request is currently denied as to both parties.
Okay. Can we have a review date though, perhaps maybe?
That I will set on the calendar, Mr.
Okay,
Blanchard.
thank you. I would suggest a couple of months down the road, Your Honor.
I would agree, Mr. Blanchard. I think that's an appropriate proposal. I want to see how this goes. Mr. Matlock, you need to exercise each one of these visits that the court has ordered.
Yeah.
I mean, if you want these parenting rights, you have to exercise them.
Right.
And I expect you to be there during these parenting time periods. Now, it's not your significant other's parenting time period or your parents, it's yours. I expect you to be actively involved. If you got a 3-year-old girl in the house, you don't have any choice but to be actively involved. It's a busy time, Mr. Blanchard. Let me see if I can find an appropriate date. Mr. Blanchard, if I were to propose 11 o'clock a.m. on Monday, May 12th.
Checking, Your Honor, I'm an old guy, I just do a paper calendar, so
Oh, no, that's the best kind, Mr. Blanchard.
yeah, 11 o'clock on May 12th is open, Your Honor.
All right. The court will conduct a Zoom status conference May 12 at 11 o'clock a.m.
Okay.
Further proceedings in the case, I will make both parties aware the court would consider modifying orders at that time to the parenting plan if the court believes it's necessary. And with that date now set, May 12, 11 o'clock a.m. by Zoom, I do wish to make this point. Ms. Martin, you do not have a superior right under the law to custody of this child. A father has just as much right to make a legitimate claim for custody as you do. You have been the primary parent. I have no doubt you love your daughter. I have no doubt you care about her. But if you can't work with the other side, what the court has an option of doing and has exercised before is place the child primarily with dad and see if he will work with you better than you work with him. So my admonishment is follow this parenting plan, find a way to work with the dad. You've got 15 more years plus to work together concerning this child's welfare. You need to start now to really develop cooperation and a rapport so that she doesn't see conflict between the two of you. And she has a normal relationship with her mom and a normal relationship with her dad. I expect you to be equally willing to work with mother, Mr. Matlock.
Yes.
All right.
Your Honor,
Mr. Blanchard, memorialize this temporary parenting plan in a court order stemming from today, setting forth the date for review in such order. Is there anything else, Mr. Blanchard, we need to address today?
No, Your Honor, I'll prepare an order and the parenting plan I've already prepared and submitted to the court. Do I need to submit it to Ms. Martin for her approval first?
You do.
Okay.
Ms. Martin, he's going to submit the proposed order. You may not agree with everything that the court's done, but if it accurately reflects what the court has done, you need to give him your approval promptly. I don't want that order held up. I want to make sure both parties have an order they can show law enforcement to make sure the other side is following it. So the sooner we get that signed and filed with the clerk's office, the better off everyone is.
Okay.
And I have no doubt Mr. Blanchard will be very, very prompt in the preparation of this order.
I'll try to have it out today, Your Honor. Thank you.
Excellent, Mr. Blanchard. I appreciate that commitment. Good luck to both parents in working together for the best interest of their child.
Appreciate it, Your Honor. Thank you.
All right. If there is nothing further at this time, then this matter is currently in. This matter comes before the court at this time for review of case status. Back on March the 7th, this court had a non-evidentiary hearing. The court ruled that the motion to modify the parenting plan stated a prima facie case. The court granted as a temporary order a parenting plan with every other weekend visitation, Wednesday night start, and the court set a review hearing today. That was eventually journalized, I believe, by Mr. Blanchard. Court also notes that there is a motion currently before the court that was filed back on May the 1st, where there was a request for this court to appoint a guardian ad litem or a domestic conciliator. Mr. Blanchard, what is the current status of this matter?
Yes, Your Honor, can you hear me?
I can.
Okay, yes. It is set for review today, Your Honor, and it also is set for the motion that we filed because we believe independent third party who could, who's a professional, could provide the court with needed information and perhaps avoid the necessity for a trial. I would tell the court that all the concerns we had that were filed in our verified motion are largely still present in this matter. The expanded visitation that the court ordered that we started getting after the hearing on March 7th has gone reasonably well in terms of the child, my client having more access with the child. There was one, I just call it a hiccup, when my client was out in Western Kansas coming in and called Miss Martin and said he'd be just a little bit late picking up, would his father pick up? And she didn't want to do that initially, but eventually my client's father did pick the child up. My client was going to be 15 or 20 minutes late. So that went through all right. There have been concerns about how the child is when my client picks the child up. My client reports, and his wife or fiance also reports, that the child often comes not bathed, with her hair matted, and not appropriately clothed. And especially one day when it was about 50 degrees out, she was not appropriately clothed at all. My client did say that the child is happy, comfortable, enjoys being with him and with his fiance and with his other family members. They're all closely bonded with each other. The child has opened up to him more and more with the expanded time that he's had, which is very comforting to my client, very encouraging to him. He is very, very concerned about the arrangement that she comes from. We still believe there was one occasion when my client and his fiance picked up the child, Lyric, in April 20th, I believe it was. And Miss Martin did have a significant odor of marijuana on her person, which caused my client concern, which caused me to then file the motion after I was given that information, filed me a motion to have an independent third party do an investigation. It is an issue. We thought we adequately prepared it for the court and provided exhibits at the last hearing on March 7th. I respect the fact that the court did deny that motion. We're kind of renewing this motion again. At that time, we did offer that we would pay for the test of the cost of a hair follicle drug test, and that my client would also submit to a hair follicle drug test and pay for both. And we are renewing that motion, that part of the motion today on the review hearing. I would say that my client has had another child since that time, and Lyric seems to be very comfortable and happy to have another sibling in the house. That my clients have. My client, Mr. Matlock, does have appropriate housing. The child has her own room in his house. As we reported the last time, Lyric, the child, sleeps in the same bed in the same room where Miss Martin resides. There are 6 people, 5 adults and Lyric in that house. It has one bathroom. It's a very crowded place for the child, and we don't believe that is the best situation for the child to be in at that time, at any time. But we think that situation should be corrected in some way, and we think more time with my client would make that a better situation. I would tell the court that my client did send an email or a text message to Miss Martin to see if they could discuss it on their own and arrive at him having some expanded parenting time. Her response, according to my client, is she said, "No, I think things are going well the way they are, so I'm not wanting to expand your time with Lyric." And so they never sat down and talked about it, which I think would have been a good idea if both parties went in with an open mind. And I understand Miss Martin's position is that she doesn't want to give up any more time than she has to with the child. But still, I think part of the thing about a review hearing and for the court to determine how things have been going, that the parties to discuss and try to work out an arrangement on their own would be the preferred way to do that. If we have a guardian ad litem and or a domestic conciliator, they could go through the mediation process, and then if that doesn't work, then an investigation can be done, and the court would then have an independent third party who could report what that person thought, who's a professional, was in the child's best interest. So those are the things that are a great concern to us. I would tell you that, and this happened just yesterday morning when Lyric was in my client's home, and Lyric, according to my client and his fiance, said that Lyric didn't want mom to call the police again So Lyric would have to leave dad's house and go home, which suggests to my client, and that happened once before, and that was one of the things that spurred on the motion that we filed back and heard on March 7th. It certainly would seem that Ms. Jordan is probably discussing things with Lyric that are not in her best interest. What we would propose, Your Honor, in the interim, if the court would appoint a guardian ad litem or domestic conciliator, is that we would expand my client's parenting time to every other weekend that he has the child overnight on Sunday to Monday mornings, and he has every Wednesday night until 7:30, and we would like that expanded overnight to Thursday morning. We think this would ease the transition even more, pending the report if the court orders it. And we also would say if the court would grant our motion to have hair follicle drug test by both parties, that if either party tested positive for an illegal drug, that we could file an emergency motion for the court to consider that issue. So those are the things before the court today. And again, we're renewing the motion for the hair follicle drug test.
All right, the current parenting plan is Henry having the child every other weekend from Friday at 6 to Sunday at 6.
Yes,
And
Your
then
Honor.
every Wednesday for 2.5 hours, correct?
That is correct. And then there is a specific holiday parenting plan as well in place.
All right. All right, Ms. Martin, you've patiently waited for Mr. Blanchard to make his opening statement here. Do you have any response to what's being proposed?
There was a lot said, but I do have a comment on the fact of the police officer. The whole incident, I'm not disclosing or talking to my 3-year-old about things that she should have no clue about or is going to be confused about. She has all of a sudden randomly, she's been coming to me on the last day that she gets dropped off, and later at night she tells me she loves me and all this and that, and then she tells me that she wants me to call the police officer to have the police officer come get her because she doesn't want to be at her dad's at night. She wants to sleep with me, but I tell her that we can't do that, and that's you have to be with your dad, and your dad wants to spend time with you on the weekends. And I'm not doing anything wrong. I'm not discussing or disclosing anything with her that I should not be, or that's above her age level.
Where would she get the idea that a police officer can come get her and take her away from her dad?
Because that one time that we went, that I had to call the cops to get her back. I don't know why and where, but she tells me pretty frequently that she loves her dad, but she doesn't like staying the night there. She tells me, I cry for you all night, Mom. I tell her, I'm sorry. There's nothing I can do.
All right.
May I respond to those comments, Your Honor?
You may.
Thank you. The whole thing was started because she called the police because there wasn't any specific parenting plan in place at the time, and she did call it for a welfare check. And then the police officer did say that there was nothing wrong, but he said let the mother have the child for a moment, and then the mother would not, Ms. Martin would not let the child come back to my client, even though they had been following a de facto schedule. There was nothing in a written order as to what a specific parenting time was. And the officer said, I'm sorry, this is a civil matter. If you don't have it on paper that you have this specific time, there's nothing I can do about it. That's what it is. And it was an inappropriate call from our position with regard to the time that she called the police and was out of anger on Ms. Martin's part because she wanted the child back and it wasn't her time to go back under the de facto plan. One thing that's just telling by her comments about the child, and my client would say the child does not cry overnight when she spends Friday night overnight and Saturday night overnight, that the child is very comfortable and happy there. So he doesn't know what that's about, but we have people there that could testify that that is not the issue when the child is there. And the people would testify as to what I've already described to the court today as to how comfortable and happy the child is there. But the one telling thing that Ms. Martin said in her response to my opening argument was that the child wants to come back and sleep with me, which confirms that the child who is 3 years old going on 4, it continues to sleep in the same bed with her mother which we think that is a concern for the development of a child over time. So with that said, Your Honor, we ask the court to rule on the arguments we made in the motion and the review hearing today.
All right. Before the court would consider the appointment of a guardian ad litem, the parties would have to commit to providing sufficient funds into, say, Mr. Blanchard's client trust account that would of at least $1,000. It would be very difficult for a guardian ad litem to do their job without at least that much time involved in investigation and report writing and the like. And even that is a very conservative amount. Could your client commit to the $500 necessary to deposit for that purpose, Mr. Blanchard?
Yes, Your Honor.
And I trust Ms. Martin, you could do the same?
No, I couldn't.
Okay, are you working currently?
I am, but I'm trying to get out on my own.
Okay, well, all right.
Your Honor, we would, my client would upfront $1,000, so Ms. Martin's portion would be paid, and reserve the issue about any reimbursement.
Understood. And I think that's a fine gesture on his part to do that, Mr. Blanchard. Who would you propose be appointed as guardian ad litem in this case? There's a couple of names in mind,
I
but
don't remember her name. It's Sharon, I think you've used her before. Is it Sharon Leal? There's somebody in Butler County that I think does a very nice job, and her name
we're
is
talking about Susan Locke?
Susan Locke. That's it. Yes, Your Honor. Or Josh Andrews. I've used Josh before too.
All right. Would be comfortable with the appointment of Susan Locke, but Mr. Blanchard, if you will check with Ms. Locke to make sure she's available to perform this task.
Okay. And if she's not, with an appointment of Josh Andrews, would that be appropriate with the court if Susan is not
It
available?
would be if he would commit to being available for this purpose.
Okay.
And hopefully you won't have to go to a third name, Mr. Blanchard.
Yes.
Ms. Martin, the court's inclined to appoint a lawyer essentially to represent the interest of the child, called a guardian ad litem. And what they do is that they make recommendations in the best interest of the child. They're a neutral. They don't represent you. They don't represent Mr. Matlock. They represent the child's interests.
Okay.
So they would do an investigation. I would expect you to cooperate with whatever questions the guardian ad litem has. If they need documentation from you, whatever it might be, they may even come out and want to do an inspection of your premises. And the court would expect that you'll cooperate with that as well, if that is requested. And then this person would make an independent recommendation to the court as to what's in the best interest of your child, which the court would put some weight on. It may or may not be controlling, but the court would certainly consider the recommendations of this third-party attorney who's representing the interest of your child. And Susan Locke will be the first one to be approached, and then Josh Andrews after that. And you'll journalize this guardian ad litem order, Mr. Blanchard?
Yes, I will, Your Honor.
Mr. Matlock, the commitment's been made that you'll deposit $1,000 for this purpose in your attorney's client trust account. Mr. Blanchard, my policy is you don't disperse money out of that account without a specific order of authorization from this court.
Okay, yes, Your Honor, I understand that.
All right.
May I ask about the request to expand his parenting time and the, with regard to overnight on Sundays on his alternating weekends and overnight on Wednesdays when he has the child during the week?
Ms. Martin, I don't know that you specifically addressed that. The request has been made to allow another overnight during the week and on the weekend. Your position?
I don't think that that's very wise at her age because she's going to be starting school soon. So I think that that's going to be a little hectic.
Okay, first of all, the traditional school year is about ready to end. We're going to get into the summer.
Yes.
And she is just ready to turn 4, so she won't be starting kindergarten.
No, but she's going to be in pre-K all day until I get off work.
Okay, and that would start what, in August sometime?
Yes.
All right.
So if during the summer, if overnights on Wednesdays, I don't see why not.
And then what time would it be contemplated that the child would be returned to the mother on Wednesday, which would be essentially Thursday morning?
Thursday morning. We could do an exchange at what, 8 or 9 o'clock in the morning?
It'd have to be before 7. That's when I go to work. I could just,
But
Well,
have
that's
a-
awfully early in the morning for a
you could have
child in the
family
summer.
member, right?
I could possibly have a family member do it around
8.
7:30.
Okay. 7:30 or 8?
All right, by no later than 8 a.m. then on Thursday morning, the court will allow the expansion of parenting time on the Wednesdays. What about the Sunday night to Monday morning? Is that the same issue that he goes to work early on Monday?
Yeah, it's same, it's, I start my shift at 7, Monday through Friday.
But we can have a family member drop her off no later than 8.
If I may speak, I start work a lot earlier than both those times. I go in at 6 a.m., sometimes 7 a.m.
Okay, so who provides care while you're working?
My mom, she babysits her for me, and I pay her bi-weekly.
At your house?
Yes.
We would
Okay,
make the
well,
exchange.
the drop off would be the same, whether it's to be to Jordan or to the mother. Okay, I don't see that the Sunday overnight to Monday interferes substantially with the mother's parenting rights. She gets up early and goes to work on Monday morning. Mr. Matlock, if you want to keep the child overnight on Sunday on your weekends, drop him off essentially to grandma at Jordan's house on Monday morning, I just don't see that that would be inconsistent with the best interest of the child at this point, and the court will allow that expansion as well. I just hope that everything's going well during your time with this 3-year-old.
And Your Honor, one last time, and I want to belabor the point, but with regard to the hair follicle drug test, has the court changed its mind at all from its initial order?
No,
All right, thank you.
court still declines to order drug testing in this case.
Okay, I'll prepare the order as you have specified, Your Honor, and I'll submit it pursuant to Supreme Court Rule 170. With regard to the specific order, can I put that in, that will I have to contact you to disperse money to the guardian ad litem, or can I put that in the order that with the guardian ad litem's request, I'm authorized to disperse money to the guardian ad litem?
Yes, either the guardian ad litem can make the request to the court, or you can on the guardian ad litem's behalf. I just want to make sure that there is court-ordered authorization for any disbursements from that fund.
All right, I'll include that in the order, Your Honor. Thank you.
Please do, Mr. Blanchard. I want to set this case for a review hearing. I don't want to lose track of it. And I want to monitor progress. So what would the time frame that you would anticipate, Mr. Blanchard, to get this order done? Perhaps Ms. Locke on board, let her to do her work, and perhaps be in a position to be able to report back to the parties and the court.
I would think to
60
get,
days?
yes, Your Honor, that would be fine.
All right.
So we'd be looking at sometime in July, is that correct, Your Honor?
Yes.
Your Honor, the week of July 14th, I'm not available, but I'm available the week after that, anytime on the 21st, I'm available.
Monday, July 21 at 11 o'clock a.m., counsel?
Yes, Your Honor, that's fine.
Court will conduct another Zoom review of the status of the case, Monday, July 21, 11 o'clock a.m. Hopefully, the court and the parties will have available a guardian ad litem report by that time. If not, we'll review progress and do further scheduling as may be necessary at that time.
Thank you.
I'll look forward to receiving your order of modification, Mr. Blanchard, and we'll review the case by Zoom Monday, July 21, 11 o'clock a.m.
Thank you, Your Honor.
All right. If there's nothing further then, at this time, this matter will currently be in recess, and this meeting may be ended for all. Henry Matlock appears with his attorney, Patrick Blanchard. Joshua Andrews appears as court-appointed guardian ad litem for the child. This matter comes before the court at this time for further proceedings. This court